Hello. Welcome back. Whatever week this is. Week 8. Welcome back to week 8. Okay. So, we're going to do the judicial slideshow today. And then please remember that you have an exam this Friday, October 18th. It'll be just like the second exam. It will open, I believe it'll open at midnight. You have all day to do it. When you're done with it, you submit it, it'll be over. It should be showing you like what grade you're getting, and it should also be showing you the correct answers. There's a lockdown browser. You only get one attempt. Once you open the exam, you cannot close it. And if it pings you as having like looked around or had a different browser open or whatever it was, it'll ping it for me. Then I will review it. Please remember that this is available to you to use as your as your exam prep. This exam 2 study questions. There's all kinds of questions in here. And when I upload the link for this, I will upload a new link. I believe this link expires to join the class. So I believe it expires like every 10 days or 3 days. So when I upload this lecture and I post the link, as I usually do, like this, I will include a new link to join the class. So you can do that. Also, please remember that you have a study guide. This exam pre-quiz study guide does not have every question. There are questions that are on the exam that are not in this. There are questions in this that are not on the exam. So you should also be looking at our study guide and using that to prepare. Obviously, if you have any questions, feel free to email me or message me on Discord. I will answer that. We can also set up like a Zoom meeting if you want to talk through something. Perfect. So that's what that looks like. Remember, it's this Friday, October 18th. It will be on Brightspace just like the first one. I believe this exam has... Let me look at the first exam. Exam 1. Okay, this has 32 multiple choice. I believe our second exam only has 30 multiple choice, which means there will be 20 true and false. It'll be around there. It'll be relatively similar, basically the same thing. And then your movie assignment is due the Friday after that. So again, if you have issues, there's 2 different issues you can have. The first one being that you can't access the movie through one of the streaming services. Just let me know. We can work that out. But also, if you are uncomfortable with watching this movie because it deals with some heavy topics, let me know. We'll get you a different movie. No big deal, no problem. I have questions prepared for all of the other movies. Totally cool with that. I just need to know what you're doing. And I obviously only uploaded the questions for Spotlight, but I have questions for all the other movies. So whatever the issue is, just let me know, and I will give you the separate questions, and you can do it differently. No one has to know that you did a different movie. Obviously, no one sees your assignment but me. I'm not going to tell anyone. So it'll be just between us if you choose to do a different movie for whatever reason. But that is coming up next Friday. So please reflect. Please take some time to think about it and let me know if you have issues. Since it's due on Friday, I mean, I would hope that you wouldn't save it to the last day, but I would hate if on Friday you start watching it and then realize like, oh, you can't get to it, or you're uncomfortable and then have to watch a second movie and you're kind of scrambling for time. So just take a look at it beforehand and let me know. Perfect, cool, great. I'm just going to get right into the lecture. It shouldn't be that long, I don't think. It is not that long. So we're going to talk about the judicial branch of government today. This is obviously on your third exam. So your second exam is covering media, federalism, and then Congress. And the presidency, judicial, and what's the other one? Bureaucracy, I think, is the next one. Give me a sec. Yeah, that will be on your third exam. And then these 4 slides will be on your final. Your final is not technically cumulative in that all of the content, like you're being tested on content from earlier in the semester, but it is cumulative in the way of you need to understand the foundations of government to answer some of the questions. So this is on your third exam, so you don't need to know this for our exam on Friday. We're going to talk about the law and its role in democracies. We're going to talk about the constitutional basis for the system, how the courts are made up, the state and federal courts, the Supreme Court itself, and then the influence of the court on people, on legislation, on our institutions, all that kind of stuff. Again, very, very basics. So this is just our background. It was established by Article 3 of the Constitution, our court system. Remember, Article 1 is Congress, Article 2 is the presidency, Article 3 is judicial system. It's laid out in the Constitution exactly how I'm teaching it to you in order 1, 2, 3. That should help you remember. The Constitution actually is very, very vague about the judiciary. So the role of the judiciary has arguably evolved more than the other 2 branches. The thing about the judiciary as well is that you have life tenure, you are not subject to voters, and similar to the president, you can be impeached. So you can get removed from your role. So there are just a small handful of ways to be removed from your office, especially on the Supreme Court. This is primarily the Supreme Court that I'm talking about, unless I specify otherwise. You can be impeached. You can be you can retire. You can choose to be retired, or you unfortunately can pass away while in office. So other than those 3, there's basically no way to get off of the Supreme Court unless you want to, right? Like you choose to leave, or you have an illness and you unfortunately pass away. That's not a choice, clearly, but right, that's out of your control, but it's also out of the control of the voters or Congress. And then the only thing that is in the control of Congress is being impeached. But the voters have no rule in this. You are not subject to the voters if you are in the Supreme Court or many levels of the federal judiciary. So laws, what are they? The purpose of them is to establish social order, provide security, and then protect rights and liberty, right? We can think about our Constitution and the Declaration and rights, liberty, all that kind of stuff. There are 6 main types of law that I will introduce you to. Criminal and civil are probably the most well-known. Any case that you'll probably think of would fall under one of those 2 umbrellas. Procedural, constitutional, military, and international are the 4 other types of laws. And they are very niche, and they apply basically only to what they are regarding. Criminal and civil are very well known, they're very widespread. Most cases will fall into one of those 2 categories. So criminal law is a government law prohibiting behavior usually intended to keep society safe and secure, and it falls under the power of a government prosecutor. Criminal law cannot be filed by individuals. If you, like, I don't know, take an action against me, I cannot file a criminal lawsuit against you. A criminal lawsuit can only be filed by the government. And this can be any level of government. So this could, I mean, we very, very rarely, if ever, see a criminal law in the Supreme Court, although there have been a couple. Your criminal law likely is going to be filed by your county or your state governments, unless it directly falls under the jurisdiction of our federal government, in which case it will be filed under original jurisdiction from the federal government. And I will introduce you to original jurisdiction in just a little bit. And then the other one is civil law. So this is laws involving interactions between people. So if I take an action against you and you sue me, that is a civil lawsuit. This is a disagreement or dispute of two or more parties. Oftentimes you're seeking compensation from someone if you get into a car accident, if there's a contract dispute, if you get fired at work and you're trying to sue, anything dealing with a car accident, if I hit your car with my car door, anything to do with family law is going to fall under a civil law. Civil law is basically like anything interpersonal. Criminal law involves the government. Civil law is between people or entities, right? And then the other four kinds I just lay out very plainly here for you. Procedural law regards our legal system and how we're laying out justice. So like Miranda rights, the thing that you have to be read when you are getting arrested, and they say, you have the right to remain silent. Anything you say will be used against you in the court of law. That kind of thing. That's a procedural law. The system for how court cases progress is also procedural law, and oftentimes when there is an appeal sent, it is not because someone didn't really like the ruling or they thought the ruling was wrong. An appeal is based on a procedural breaking. So something in the actual case, like in the procedure of the trial, went wrong, and that's why we're appealing it. It can be maybe the jury was biased, or the jury was influenced by the media, or some evidence was left out and it shouldn't have been, or evidence wasn't given to the other side, or someone didn't show up, like that kind of thing. So anything dealing with the actual system is a procedural law. And in order to get a case appealed, there has to be an issue with the procedure, not with the original ruling of the case, unless the procedure impacted that ruling. The next one is constitutional law. So this is obviously dealing with our Constitution, and this is the judicial review stuff. So when we talked about the power of the courts to determine constitutionality of an executive order or of a law that Congress passed, the student loan forgiveness that keeps getting shot down, that Biden keeps trying to pass and the Supreme Court keeps shutting it down, that's a constitutional judicial review basis. They're shooting it down because they're saying it's not constitutional to do so. The Roe v. Wade and then Dobbs v. Jackson decision regarding abortion, that was also constitutional. So that was dealing with the Fourth Amendment. Basically anything dealing with the Constitution is going to fall under the judicial review. And the Supreme Court has original jurisdiction over that, which means it immediately will go to them in many cases. And then we have military law, which is obviously only applicable to military, the military itself, or members of the military. This is pretty basic stuff. It's looking at like uniform code, statutory provisions for military members, and there's generally uh, like an etiquette, like a code that they have to follow. And when that code or that etiquette is broken, you can be put on trial or sued for breaking that etiquette. Not wearing uniform properly is one. I know, like, members of the military who are married and they cheat on their spouses, that is breaking, I don't know if it's a code or an etiquette or a rule. I don't really know what it's called, but that is breaking that. And most often you will just be discharged or dishonorably discharged, but sometimes you will be put on trial for what you did, and it's under military law. And then the last one is international law, which are rules or standards that are happening between states. So if there's a case that somehow the U.S. is involved in with Canada, that will fall under international law. And very rarely in these instances, like, the Supreme Court probably isn't going to hear this case because it deals with another country. It will most likely be another court. The UN hears a lot of these cases. You can think about like World War II and war crimes, and like how those cases are heard. That is often dealing with international law as well. But most international law cases are going to be stuff like trading or currency or boundaries or borders, like interactions in water or in air over other countries, like really basic logistical stuff. Very rarely is it like a big controversial thing. And also very rarely will it immediately like come to an American government system or judiciary. That's not going to happen probably. So in terms of the United States, so these laws, these types of laws are widespread. But in terms of the United States and how we handle these types of laws, we have a federal court system and we have a state court system, which is a dual judicial system because we have a federalism form of government or a federalist form of government. So there is a distinct break in jurisdiction where something falls under the state court system or the federal court system. That way, like, obviously, there's not one level ruler on all of these cases. So the federal court system has original, quote unquote original, like they have jurisdiction over federal statutory claims and constitutional matters. Again, most of constitutional stuff will go to the Supreme Court. And then the state court system basically gets every type of case that is subject to the limits of the federal jurisdiction. This does not necessarily mean that the state court has their own jurisdiction in many things. They're getting the cases that are subject to the limitations of the federal court system, where it's, the federal court system doesn't have jurisdiction over this case. It's a state court case. A lot of criminal matters will start here and then be appealed up if they have to. Anything dealing with family law, divorce, that kind of thing. Real estate, buying a home, that's also state court stuff. And then contracts, state court stuff. Again, they can always be appealed up, and I'll show you what that appeals process looks like, but most things will start in the state court system until they get appealed. So our federal court, we have 3 levels of the court. Upon reflection, I wish I had laid this out a little better on the slide for you to visualize. But basically, there's 3 levels, and they progress from one level to the next level to the next level. So they start in the district court. There are 93 federal district courts. Case starts there, something happens, they appeal it, okay? So they go one level up, and it moves to the Court of Appeals. What graphic I'm showing you right now is the Court of Appeals district. So Ohio is in the 6th District Court of Appeals for the federal government. Obviously, if it goes from the Court of Appeals and then it gets appealed again, the next highest level is the Supreme Court. The Supreme Court, they have their own cases that come right to them, but they can also and will also take these appeals cases that come from lower levels. So obviously this graphic is only showing 11 districts. The other two are these two. So there is a DC district, which is primarily, you can see it right here, how it's like a different color, and it's not the same color as 3 or 4. It's the DC circuit, which is like the federal commissions and agencies and all of that would go to that district if it's a federal agency. And then the 13th Court of Appeals district is the nationwide jurisdiction for patent and international trade. So if you're dealing with patents or you're dealing with international stuff and you go to the Court of Appeals, there's a nationwide district. So District 13 covers the whole country, but it has to be dealing specifically with patent or international trade law. And then our state courts, they vary as well because they are state courts, right? And obviously the states have their own like jurisdiction. They have their own rule. They can make their own laws. And they can set up their district however they so choose. Most states have a 3-level system though. And it looks very similar to the federal system. So we have courts of limited jurisdictions. This is obviously like small. This is our first level. Municipal courts, small claims courts, traffic stuff. These low-level limited jurisdiction municipal courts are hearing the bulk of all cases. If the decision is made in one of these small courts and it is a procedural issue that impacted the ruling and you appeal it to the state Court of Appeals. So there is an Ohio State Court of Appeals. And I think that oftentimes is broken up into a couple of districts as well. And then from there, if a case is appealed again, it goes to the state Supreme Court. There's one state Supreme Court per state. It's the top court in the state. So here's what the system looks like moving up. So you start, most cases are going to start in your state trial courts. Probate, county, municipal, domestic relations, all that kind of stuff. And then a decision is heard, maybe there was a procedural issue, it gets appealed. You then move to the state appellate court. Okay, decision's made, another procedural issue, whatever have you, you go to the state Supreme Court. Most often, this is the court of final resort, which means you're probably not going to get past this court. Due to federalism itself and due to obviously the state and federal governments having their own ability and state supremacy or federal supremacy laws, but states having their own right to have their own laws that cannot be superseded by the federal government, depending on what the law is. This is your high level, your state Supreme Court, and you're not going to get higher than that. Anything dealing with our federal matters will go to the district courts, the U.S. federal district courts. Same thing, some procedural issue, whatever, you appeal it, you go to the United States Court of Appeals. That says 12. There's 12 in practice, there's 13 in reality. Something happens here, procedural issue, you appeal it to the Supreme Court of the United States. The Supreme Court is the highest level. If the Supreme Court rules on your case, that is it. You are done. You cannot go any higher. There is nowhere else for you to go. So, most of your cases are going to start in your state trial courts. Sometimes, depending on the matter, you might start in a federal court if it's a federal issue. But most cases will start in your state court. There are 3 ways to get to the Supreme Court, the U.S. Supreme Court. The first way is through the U.S. Supreme Court having original jurisdiction. That meaning a case in which the U.S. Supreme Court is the only ruler of that case. The second one is to come through the Federal Court of Appeals, from low level to the appeals to the Supreme Court. The third way is to come all the way up through your state systems into the federal system if there is still an issue here dealing with a federal issue. It has to be a federal issue. It will not come here if it is not a federal issue. If they cannot rule on it, it will stay in the Supreme Court ruling, and that is the final one for the state. Only if it's a federal matter will it get pushed over. Here's just what it looks like in writing. It's the same thing that we just went over. So you have a trial, and then you appeal it to the Court of Appeals, then you appeal it again to the Supreme Court. The cases that start here in these federal courts are cases dealing with the Constitution or the U.S. government, cases between states, it's like Ohio and Indiana, whatever, they have an issue, that would start in the federal court, or an issue between the U.S. government and another international government. That would start in the federal courts. I want to do this first, and then I'll come back to the slide that I just skipped. So the U.S. Federal Supreme Court has original jurisdiction in 4 ways, which is given to them from the Constitution, directly from the Constitution. State versus state matters. Again, Indiana versus Ohio, whatever. Actions involving ambassadors. So if an ambassador is involved, the Supreme Court gets original jurisdiction. Anything between the U.S. government and a state. So like the U.S. government v. Maryland, that is immediately a Supreme Court issue. And then actions by a state against citizens of another state. A really good example of this would be like before that's a good example. Like marriage issues. So before same-sex marriage was legalized in 2015 by the Supreme Court, if a couple was married in California, let's say, okay, and then they go to another state, and that state is performing an action against them, that could go to the Supreme Court. I don't really think that's a great example, honestly, now that I said it out loud. I was debating before I said it, and now that I said it, I don't think it's a good example. But it still it still stands. It's just any action a state is taking against a citizen of another state. If you, for example, go to Florida and they illegally detain you, and then they try to use terrible tactics to force you to admit to a crime, like if they waterboard you, that will go to the Supreme Court because the state of Florida is taking an action against you, who is a citizen of Ohio. This really didn't need to be that difficult. I don't know why I made it that difficult. Anyway, these are the 4 ways that the U.S. Supreme Court has original jurisdiction. So the Supreme Court, being the highest tribunal in the country, is the final arbiter of the law, which means whatever decision they make is the last decision. Nothing else can be done about it. So when people are thinking about appealing cases, this is like what they're considering, is what court they're appealing the case in. Because if you appeal it to the Supreme Court and you don't get the result you want, it's over, it's done with, that's it. You can't go anywhere else. They are charged with their responsibilities given to them by the Constitution is to ensure equal justice and to protect and guard the Constitution of the United States. Nearly all cases are coming from a lower court, whether that is a federal court of appeals or a state Supreme Court, unless it is one of these four things, in which case it then goes directly to the U.S. Supreme Court. Here's our composition of the court. Since 1869, the court has had 9 justices total. There's 8 associate justices and then 1 chief justice. The chief justice is like, I don't want to say leader because it's not really like that, but I guess you can think of it like that. The chief justice is the leader of the court. So they preside over the court. They'll assign the writing of opinions. They administer the presidential oath when the president is swearing into office. And they also are ruling over, or like, not ruling over, they're like presiding over impeachments or administering the impeachment. So if a president is impeached or another justice is impeached, the chief justice will preside over that and administer the impeachment. I want you to remember this. Since 1869, we have had 9 justices. Since 1869. However, we're going to talk about the idea of court packing, which is very political. It's like arguably the most political piece of the Supreme Court. This is the process of packing the court to potentially garner support for one side or another. So this is just a fun little political cartoon and then some information on FDR. So the Supreme Court, so FDR, obviously, when he was president, he was like trying to fix the issues that came from the Great Depression. And he was implementing his New Deal. That got implemented. It fixed some things. People were doing better. It was all cool. So then he was looking into implementing his second New Deal. And he was scared that if he did that, because it took all these extra steps, the Supreme Court would strike down his plan and say it was unconstitutional. So he came out in public and he said the quiet part out loud, basically, and proposed that he would appoint an additional justice for each justice over 70 to lighten the load. And what he meant by that, the implication was, oh, I'm gonna appoint all these new justices for everyone over 70 because you're over 70 and you're kind of getting old and we got to make it easier for you to hear all these cases. What really was going to happen was that he would put all these justices in that would overrule the justices who would disagree with his new plan. And when he said this, again, he said it out loud, which is the equivalent of saying the quiet part out loud, tell me what you're going to do before you do it. Americans were obviously very against this, and they viewed it as an attempted power grab. They're oh, so you're just doing this to have more power. So your plan definitely gets through, and then you can do whatever you want because no court will rule against you because you put your people in. He didn't end up doing it, primarily because it got really bad backlash, but also because 4 justices ended up retiring or dying, so he ended up getting to put in his own people anyway without having to actually court pack. Why this is important now is because we hear this every election where they'll talk about, oh, Biden will court pack or Trump is going to court pack. And that I'm not saying they will. I'm not saying they won't. I don't know. Obviously, no one really does except for them. But I think it's important to note that, like, this has always been a threat, and it's been much, much closer to being a reality and didn't happen because of the backlash, that the likelihood of it happening now is probably not that high. And I think we put a lot of emphasis on it, and it's probably not one of the, like, things that people on either side should be worried about. Because, again, it hasn't happened, and we've had the same number of justices since 1869, like, for a really long time. Over 150 years. So, it's not likely. Is that to say that it can't happen? No, it definitely can happen. And I think it's fair that people think about it. But I don't think it's fair that this becomes like a massive point of our media all the time. Especially when this does happen through like normal means anyway. FDR didn't have to court pack because his court died out or retired, right? Like, and he got to put in who he wanted. Same thing with Trump. Trump didn't get to court pack, really, because he already got to put in who he wanted. The idea behind court packing is specifically that you're creating new positions, which the president can do. The president can do that. Court packing is not, oh, a justice retired, or a justice was impeached, or a justice passed away, so now there's an opening the president can fill. That's not court packing. Court packing is the president saying, oh, we have 9 justices, I'm going to add 4 more. Because they can do that, but no one does. Similar to how Washington could have served all he wanted, and he set a precedent, and he got out after 8 years, and then that was precedent until FDR sat in for his like whole life, and then a law was passed that you couldn't do that. That's about where we're at with this. It is precedent that a president will not put a ton of new justices in because they can. I'm not sure, I shouldn't say that. I would be willing to throw around the ball that if a president did do that, we might see an attempt from Congress to push back against that. I think it would be difficult because that is a power given to the president by the Constitution. And, like, obviously, when the Constitution is threatened, it doesn't go over very well. Like, most people aren't cool with that. So I feel like, I don't know if it would work, but if a president did do this, they'd also get a lot of pushback, even if there couldn't be a law against it. But it is precedent that no one does. That you only replace the justices who leave office. You do not create new positions. I'm going to skip this for now. It's a little difficult. I'm going to come over here to talk about the Supreme Court itself. So right now, our Supreme Court looks like this. Our Chief Justice is... Nope, that's not true anymore, I don't think. I think this is old. Hold on. Really? I don't know why I thought that he had passed away. That's kind of stumbled me. But anyway, our current Chief Justice is John Roberts. And he was appointed... Where does it say? Does it say that? It does not say. I believe he was appointed by Bush 2. Yeah. This is a good photo, though. I want to show you this photo. Here is our current Supreme Court. This lays it out for you right here. So, front row, left to right. So, our Chief Justice is this guy right here, John Roberts. He's in the middle. He was appointed by Bush too, and then he's on the top, not in order like this because he's the Chief Justice. Clarence Thomas was appointed by our first Bush. This is him right here. And then Samuel Alito, he was also appointed by Bush too. He is this one right here. Sonia Sotomayor, that's not how you say it, Sonia Sotomayor. She was appointed by Obama. She's right here. Oh, it's frustrating. I wish I could. I'm gonna make this smaller. Maybe I can't. Whatever, it's fine. She was appointed by Obama. Obama got 2, so he got Sonia Sotomayor and then Elena Kagan. That's her over here. And then Trump got 3. So he got Neil Gorsuch, Brett Kavanaugh, who had a lot of controversy, and then Amy Coney Barrett. So this is Neil, and this is Brett Kavanaugh, and then this is Amy Coney Barrett. And then Biden has gotten 1 appointment, and he appointed Ketanji Brown Jackson, and this is her over here. So this is our current Supreme Court. And it is a conservative leading Supreme Court. Please remember that when I say it is a conservative leaning court, I'm not talking about Republican Democrat. To be fair, yes, it is conservative because Republican presidents got to appoint more justices than Democratic presidents, right? Our Democrats got 3, and our conservative presidents got 6. So, yes, but that does not mean that the justices themselves are Democrat or Republican. They are just more conservative or more liberal. And this is what it looks like. So we have 3 pretty liberal justices, and then we have 6 pretty conservative justices. Clinton did get to appoint his own. Sorry, I know that it's super loud when I type. I realized that last time. I'm trying to type quieter now. Clinton did get to appoint his own justices. Unfortunately, none of his justices are currently on the Supreme Court. Unfortunately, because they have passed, except for Harry Blackmun, who retired. But the most famous Clinton appointee is Ruth Bader Ginsburg, and she has passed, unfortunately. So that's what the court looks like. I wanted to get through that before I talk to you about this. So how do you file to the Supreme Court? You have to file a petition for a writ of certiorari. That has to be submitted. The writ of certiorari is a request that the Supreme Court orders a lower court to send the record. So what this is a writ of certiorari is a request, basically, for the sake of purposes, your request. So you send a request, you send a writ of certiorari, or a cert, asking the Supreme Court that they ask the lower court to send the record for the case. The writ of certiorari does not immediately go to the Supreme Court. It goes to the Solicitor General. The Solicitor General's clerk then forms a discuss list of all of these cases, which is then reviewed by the justices. The justices use the rule of 4 to determine which cases on this list will be heard. You need 4 justices to decide whether they're going to hear or deny the cert. The rule of 4, I want to clarify this, is not the decision of the case. The rule of 4 is not this is unconstitutional or this is not unconstitutional. The rule of 4 is whether or not the justices are going to put the case on their docket. About 7,000 cases are or writ of certiorari are sent, requests are sent to the Supreme Court. Only ever about 100 total are reviewed. If the rule of 4 accepts the cert, then it goes on the docket. Once it is on the docket, then they hear the case. So then you get to hearing the case. Okay. And this is very procedural. This is laid out the same way every time. They have oral arguments. So the attorneys for the cases, for each side of the case, are permitted 30 minutes to present their case to the justices from the bench. The justices will then ask the attorneys questions about the case, or why this is the case, or why they think this, or how this is applicable, whatever it is. The justices are at this big bench. They then, after the attorneys present their case for about 30 minutes, the justices will question them. After all of the questioning is done, the justices go into a closed conference to discuss their thoughts. Then they vote, and then they write their opinion. Similar to a jury, there's no one in this. You don't know what they're talking about. You don't know how this is happening. They do this closed. It's a closed conference. There's no one else there. It's just the justices. After they vote, then they write their opinion. There are 3 opinions on a Supreme Court case. There's a majority opinion, a dissenting opinion, and a concurring opinion. Every case will have a majority opinion. It is the decision of the court. Most cases, unless it's unanimous, will have a dissenting opinion, which is the opinion of the justices who ruled the other way, but got overruled. Sometimes, more rarely than a dissenting opinion, there will be a concurring opinion, which is an opinion written by a justice that agrees with the decision, but they disagree with the legal reasoning of it. So a majority opinion is, yes, we agree that this is constitutional and this is why it's constitutional. A dissenting opinion would be the other justices saying, no, we think it's unconstitutional and this is why, but the decision, let's say in this case, because there's 6 conservative judges, is that it is constitutional. So the decision is that it's constitutional, but the dissenting opinion, marked by the judges who voted the opposite way, is why they disagree. And then the concurring opinion would be written by one of the 6 justices who voted for it to be constitutional, but they disagree on why. So maybe the majority opinion is saying this is constitutional because of the 12th Amendment. Okay? The concurring opinion will say, yes, I agree this is constitutional. However, I think it's constitutional based on the 15th Amendment, or whatever their reasoning is. They agree on the outcome. They disagree on the legal reasoning. The dissenting opinion is a total disagreement of the actual decision. And the Chief Justice decides who will write these. From the people who voted however they voted, the Chief Justice will pick who's going to write the majority and who's going to write the dissenting. If there's a concurring opinion, most often it's like one judge who has that, and so they're kind of just automatically given that opinion to write. But if there's more than one, the Chief Justice will also assign that. How do you get to be on the Supreme Court? It's a lot more steps than you might think it is. So the unofficial first step is that there has to be an opening. So someone has had to retire or be impeached or pass away. From there, the president gets to appoint someone. So oftentimes presidents will have like a backlog of list of like, oh, these are people I think would be good. And then when they get the opportunity, if they do, they'll go through that list. But they'll have like a basic list of who they think they would nominate already in their head, at least. Once they get a choice or chance, they will then appoint. After they appoint, and keep in mind, in order for the president to appoint them, they have already gone through multiple levels of vetting by the president's team. After the president appoints them, then they have to do a background check from the FBI. So the FBI does a background check. After the background check, the Bar Association, the American Bar Association, rates the judge on whatever criteria they're rating them on. If the judge passes that rating, and they pass the background check, and they've passed the president's vetting, all of these has happened in that order, then the lobbying commences, which is where the president's people of the president's party in Congress, people who have political power in D.C., they'll start lobbying. So they'll go around to all of the Congress members and they'll lobby for, advocate for this person to be appointed. Really, what's happening is the president is nominating. But we use the word appointment. It's kind of confusing. I don't know why we do that. The president is nominating, and then Congress is actually appointing or confirming them into office. After the lobbying has started, they'll do lobbying for a little while, and then it goes to the Senate. From there, the Senate Judiciary Select Committee will investigate. They'll look at all the background checks, they'll look at all the lobbying, they'll look at the ratings, they'll look at the vetting, they'll look at all that stuff. Then they'll hold a hearing. And what they'll do is oftentimes they will have the nominee sit in front of the rest of Congress, and they will ask them questions. And this can go on for weeks. Sometimes it can be over in a couple of days. Sometimes it can go on for weeks or months. After the select committee has sufficiently asked all of their questions, oftentimes they got from the lobbying, then the whole Senate will vote. That's annoying. Sorry. As long as the whole Senate votes to appoint or confirm, then that justice will be sworn into the court. Then they will start serving. Once you are sworn in, you can only rule on cases that have been heard since you've been there. The court does not stop when a position is open. So they're still going to hear cases, just the 8 of them. And if you join before a decision is made, you don't get to rule because you haven't been there for hearing the case. You only get to rule on cases that you were there for the hearing of. So if you get sworn in on February 12th, you only get to rule on decisions that the case is started on February 13th. If there was an active case going on and they present the ruling on February 13th, you do not get to be part of it. Here's our Supreme Court. And then just a little bit about their influence. Justices can push opinions one way or another, and the president is often subject to the ideology of Congress, right? So if you have a Congress that is of the same party as the president, it's probably going to be easier for them to get whoever they want appointed. Whereas if you have a Congress that is the opposite party of the president, you're probably going to have to put in more moderate people because Congress won't approve them otherwise. So Clinton had an opposite Congress, so he had to put in moderates at the time. Bush, too, had a great time. He had a Republican Congress, so he got to put in whoever he wanted, and they got confirmed. Obama actually had an opening during his term in March. So Obama was elected in 2008 and then elected again in 2012. In March of 2016, there was an opening in the Supreme Court. And the Senate, when Obama nominated someone to fill that seat, the Senate basically said, the Senate run by Republicans at the time, this is how party politics plays into it, said, no, we're not gonna hear your nomination because the election is happening in November, and it should be up to the voters that they decide who the president is, therefore they get a say in who sits on the Supreme Court. So even though it was open in March, it was stonewalled, which basically means that they just weren't going to hear the case. And then obviously Trump was elected, and so when Trump took office in January of 2017, he had an open spot basically waiting for him that he got to put in who he wanted. And you can see how party politics plays into this, because then when Trump was president, there was an opening in September of 2020, which was 2 months before the election. But there was a Republican-led Senate. So even though now it was 2 months before the election, they let Trump's nominee go through. I think it's important to mention here that more so than party politics, it was the same person. So the same politician who didn't let Obama's nomination go through was the same politician, the same Congress member who let Trump's go through. Which is just speaking, right, to like not only how a divided or unified government can impact the Supreme Court and legislation and what things get passed and what things don't, but also like the power specifically of these people in their roles. Because maybe that would have still been the case if it was a different person leading the Senate. But because it was the same person, that is more merit to the party politics half of it. That person was Senator Mitch McConnell, in case you were curious. So that is all I have for you on the judicial system. I'm going to upload this, and then I will also link the link to join the quizzes so you can practice for our exam. And please, 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 please let me know if you have questions about our content, but especially if you have questions about the exam that is on Friday. The exam is on Friday. It opens on Friday. Thanks so much. Bye.